Thank you guys for coming. I think, Lori, what is this, maybe our third stakeholder meeting? Okay, great. So we want to give everybody an update on our progress with delegation for the oil and gas waste streams from EPA. David Galindo, the director for the division, and I would like to welcome you to our third meeting. We also have with us Charles McGuire. He's from EPA Region 6. Stand up and turn around, Charles. But y'all all know Charles, right? So we're going to get started. We've been making constant and steady progress on the delegation package, and we have a few things to update you on, and we'll open it up for questions. We got lots of good questions last time, so please bring up any ideas that we haven't thought about or questions we haven't thought about. Is very helpful to us. And I think we're being webcast, so okay.
Oops. All right, I'll get us started off. Our first topic is our rulemaking. That's the rulemaking to amend Chapter 305.541 to adopt by reference the oil and gas effluent limitation guidelines in 40 CFR Part 435 and 437. So the rule was published on January 10th of this year. We had a public meeting on February 4th, and the comment period closed on February 11th. We received comments from 6 organizations and upwards of 1,400 individuals. So we are evaluating those comments, responding to those comments, and making any necessary rule and preamble changes based on those. And so our next step, so we'll finalize our rule package, and then we'll brief our internal management. And then once we're through our briefings, agenda backup for that document will be May 1st. So that's when the public will have access to it on our our TCQ website. And then adoption agenda will be on May 20th. So that is winding down in the final stages at this point. Are there any questions on that rulemaking? And I guess I'll just make one other housekeeping note. If we do have questions, if you'll wait for the microphone, that way the folks that are watching the webcast will hear the question and the answer. So any questions on the rulemaking? Okay. Then I guess we'll move to the next topic, which is our NPDES application. So we've been working on that application, looking at our 1998 application. I wasn't around when that happened, so I'm trying to play kind of catch up and what they do back then. We've been working with EPA. I think we've probably blown Charles's email up with questions about who, what, when, where, how. And so one of the things I'd like to share is that all that time I spent just poring over our application from 98, while it was somewhat helpful, not as much, because Charles let us know that we're not actually supposed to go back and revise that application. That application was a point in time, and we were asking for delegation for other programs, our industrial wastewater discharges, our domestic wastewater discharges, sludge program, pretreatment program. And so that application had to do with those programs. And while the basic program elements are the same, this application is going to be about oil and gas discharges. And so we're going to have to move forward with that application addressing oil and gas discharges. It's going to talk about how we plan to review and develop permit applications for those types of discharges, how we're going to monitor compliance and enforcement of those particular discharges. And so while some of that is very much the same as how we are going to be doing our other program, this application is going to be very specific to just oil and gas discharges. And so that's kind of a new set of goggles that I've put on, and so we are moving forward in that respect. And then the other thing that we have learned is that there's kind of two ways to do an application. We're either asking for a revision of our current delegation, or we're asking for essentially like a new program. And so this being a new program, in the regs, that's considered to be a partial program. Partial in the sense of we're taking a whole new program, that program being oil and gas discharges. Don't think of it as partial as in partial oil and gas, like we're taking part of the oil and gas, but not all of the oil and gas. So it is a partial program, and that was one of the things that we kind of early on had some, I guess, misunderstandings about, is we were thinking partial as in we're only taking part of the oil and gas. And we're like, no, we're not taking part of it, we're taking all of it. And so it's that partial, the word partial, that's really kind of thrown us for a loop. But now we understand it. In working with all of our partners, we've come to an understanding of what that is. And so now that we have that understanding, we have a better sense of kind of what the steps are once we put together our application. And so I just want to briefly kind of go.
Can I interject for just one quick
Absolutely.
second? Two things. First, the clarification from EPA about, we're just going to do an application focused solely on oil and gas, I think was very helpful, because we can be more efficient in our submittal and also in the information that we need to provide to EPA. So it certainly shortened the amount of work that we have to put together. It's still a bunch of work, but we don't have to look at all of those different areas that she spoke about. So, and then secondly, we learned that Oklahoma submitted their information to EPA quite a bit of time before Texas did, and EPA has looked at the process for approval of that, and they've notified Oklahoma back in January that a revision to their program was not going to be sufficient. They would have to apply for a partial program authorization. I guess the full name would be a partial program authorization application. And so that has really kind of the full process associated with it, notice, and also a hearing, opportunity for a hearing, EPA's form of hearing. And so in talking with EPA, that's what we would need to do. And at this point, I think it's helpful for us to be clear about what the process is going to be and the steps that we need to take so that, again, we can be efficient and expeditious in our submittal to EPA, and we aren't bogged down by questions about which box it's going to fit in. So with that, Lori, you can take it over, and then we will open it up for questions on those.
Yes. Okay. So the partial program is going to comply, will have to comply with 40 CFR Part 123.21, which involves all the elements of a program submission. So it'll have to include a letter from the governor, a complete program description, which is described in 123.22. Again, that's going to be your permitting as well as your compliance and enforcement. An Attorney General's statement, and a memorandum of agreement. So we currently have a memorandum of agreement. So that is actually a living document. So unlike the application, so our application from '98 was a point in time that we were asking for delegation of those specific discharges. This application will be oil and gas specific. But our MOA is how we implement our program not only now, but moving forward. And so that document is a living document and will be revised. So we'll be starting with our MOA and making necessary revisions to accommodate the oil and gas discharges. And then we'll have to include copies of our state rules and regs and statutes that are applicable to oil and gas discharges. And then moving into the approval process, EPA will have 30 days, and I'm just reading the federal regs here. Within 30 days of receipt, EPA will notify the state whether the submission is complete. We're going to assume complete. So we're going to jump down to 123.61, which is the approval process. So after determining that a state program submission is complete, EPA will publish notice of the application in the Federal Register and in enough statewide newspaper, it says largest newspapers in the state to attract statewide attention, and mail notice to persons known to be interested in such matters, including all persons on appropriate state and EPA mailing list, all permit holders and applicants within the state. It goes into details about what the notice has to include. Getting back to the approval process, within 90 days of receipt of the complete program, Submission, EPA shall approve or disapprove the program based on the requirements in the regs and the Clean Water Act. And if the administrator approves the state program, he or she shall notify the state and publish notice in the Federal Register. Any questions on our application, the MOA? Those are kind of the things I wanted to share with y'all about what we had learned.
Quick question, I'm confused. You mentioned notice and public hearing. Is that, I'm not clear on, is that after you've submitted to the EPA and they've declared it's complete?
That's correct. After
Okay.
EPA, we submit it, they determine if it's complete. Within 30 days, they have to review it to determine completeness. Once they've determined it's complete, EPA will publish in the Federal Register.
And then you have to hold some sort of comment public hearing within a certain number of days after they've
I don't think
declared it complete, or it doesn't?
TCEQ doesn't, EPA does.
Oh,
Right.
EPA holds the
Is that
hearing.
right, Charles?
Okay, EPA hold the hearing, receives comments, and they have 90 days after that public comment period to approve it, or 90 days after they've declared it?
It's 90 days after.
After submission.
It's all concurrent, okay.
Yeah, Charles said it's all concurrent, all within that
Thank you.
span.
Within 90 days of receipt of the complete program, they have to make a decision.
So the MOA,
A,
I always get them confused.
me too.
So the MOA will be just for the oil and gas.
No,
There we go. We're gonna have to do some updates to the MOA, and also, because we have to clean it up to make it current. You know, we're organizationally, we're different than we were 22 years ago. And so we're gonna have to do that type of cleanup as well, and then we will have an oil and gas piece of it.
So it'll be a new section. So you'll do cleanup and then there'll be sort of
I
a
think
new
we're working on
section.
how it's gonna be organized, but we're really gonna try to, I think right now we're trying to have it as its own piece and maybe refer back to different elements, because we're gonna process it as an industrial permit. And so we're working out the logistics for that, but there will be some overall updates to make them current.
And one of the examples of the updates that we're making, obviously organizationally wise, we're very differently organized than we were back in the day. But for instance, we repealed our basin cycle rule. And so the basin cycle rule is mentioned in the MOA. Now that that's repealed, that's one of the changes that we would be making. And that's more of just a cleanup. We've got some rules since House Bill 801 occurred. This application predated that. And so post House Bill 801, there's a lot of our rules that we're in the process of repealing because they're now obsolete. And so making sure that our rule citations are correct, those type things, when we say updates, that's what we're referring to.
There's a little bit of a pause before the green light comes on. But our main focus will be oil and gas, the changes, so.
Is the MOA itself a public document that can be commented on, or is one commenting on the application, the overall, everything?
I think you'll be commenting on the package that's sent to EPA through the EPA. There won't be a state process. You'll comment through E EPA.
Any other questions? All right, then I'm going to take a break and switch gears over to Kathy Humphreys to talk about her part of this process.
We've been working the past couple of months with the Railroad Commission to update the MOU that we have between the Railroad Commission and the TCEQ to implement HB 2230 as well as 2271. On February 12th, the TCEQ proposed rulemaking to implement 2230 and 2271. On February 11th, the Railroad Commission proposed amendments to 16 Texas Administrative Code Section 3.3 to implement the changes. TCEQ's proposed rulemaking would repeal existing 30 TAC 7.117, which adopts by reference the MOU between the Railroad Commission and the TCEQ. Then, and it will also adopt the full text of the MOU between the Railroad Commission and the TCEQ under new 30 TAC 7.117. The proposed new 7.117 includes changes to the existing MOU with the Railroad Commission regarding the transfer of responsibilities relating to certain discharges from the Railroad Commission to the TCEQ required by HB 2771, and the dual authorization of Class 2 and Class 5 injection wells required by HB 2230. The proposed amendments to both 16 TAC 3.30 and 30 TAC 7.117 were published in the February 28th issue of the Texas Register. The TCEQ will hold a public meeting on our rules on March 23rd. The comment period for our rules ends on March 30th, 2020. Our rule is tentatively scheduled to be on the agenda on June 10th, 2020. And now it goes back to Lori. Are there any questions on the work between the MOU?
Does the Railroad Commission rulemaking have the same basic time period in terms of comments, or you're not sure of that?
I'm not aware of that.
Okay.
Our railroad partner said yes. All right. So we actually put her in the middle because of my presentation, because hers actually segues into my next topic. And this actually came from one of our questions at a previous stakeholder meeting. We had a question about how the transition of permits is going to work. Specifically, those folks who have an existing permit, are they going to remain in effect, or are they going to expire immediately upon delegation? And so that's why L'Oreal said, y'all's comments do make a difference. As a result of that question, the MOU, see, I do the same thing, MOU with Railroad. So that document actually lays out the transition from railroad permits to TCEQ permits. And so what it essentially says, so I would encourage everyone to go read that section, because we plan to pattern our transition from EPA to TCEQ very similar to that. And essentially, it's easier for me to just talk than to read. Essentially, for a pending permit, so if a permit is pending, an application is pending with Railroad or EPA, as the case may be, that entity would continue to issue that permit. So they would just move forward through issuance. And then for existing permittees, so they're in the middle of their permit term, those enforcement authority would switch to us immediately upon delegation. And then those would be, so we've got an EPA permit and we've got a railroad permit, and those may or may not have the same expiration dates. Chances are they won't. And so what we plan to do is the earlier of the two expiration dates is when we will roll both permits into a single TPDES permit. So existing permits will remain in full effect and force. We will have enforcement authority of those permits, the two, Railroad and EPA. And then it'll be converted to a single TPDES permit either at the earliest of the expiration date of whichever one expires earlier, or if we get an amendment request. So that's how we plan to transition existing as well as pending applications. Any questions on that? All right. Oh, wait.
I just want to make sure I understood when you said an amendment request. If we were amending a permit that was already in existence, it would go through TCEQ at that time?
If that amendment request is pending,
Not pending, if we were going to make a new amendment during that time.
after delegation, so when we get delegation, if you have an existing permit and then post delegation you want to amend that permit, when you submit that request for an amendment, it would come to us. We would process that, and we would combine your EPA and railroad permit into a single permit during that amendment action. Any other questions? All right. Our next topic is revising the hydrostatic test general permit. So we currently have a general permit for hydrostatic test discharges. It is going through the renewal process right now. That renewal is not going to include the oil and gas because at the time that we started that renewal process, we were already past our EPA review. And so had we added the oil and gas to that renewal, it would have potentially delayed that permit to the point where new facilities couldn't get coverage under the permit because we wouldn't have gotten it issued in time prior to its expiration. So that permit renewal is proceeding. I believe we're going to agenda for that one tomorrow. So I'll get to sit in this room again tomorrow. So that renewal is going to go to agenda tomorrow. But we're also, simultaneous to that renewal going forward, we've also started on a revision to that permit to incorporate the oil and gas discharges. And so that is being drafted. We've looked at EPA's permits. We've looked at other states' permits for hydrostatic test discharges. So we've kind of done a little bit of research to see what other states are doing, what's in the EPA permits, and with that information, we have started drafting a permit. Our normal review process, we would go through management briefings after we get the draft finished. We would go through management briefings for permission to go to EPA review. After EPA review, it would go through public notice and comment. And then after public notice and comment, it would go to commissioner's agenda for adoption. So that's our normal process for general permits, renewals and amendments. And on this, because we're, one thing, anybody who's a current permittee for hydrostatic test general permit, what we're planning to do for those facilities who are currently authorized, we're gonna be readopting that permit probably, hopefully, if all goes well tomorrow. So permittees who are currently authorized under that general permit have a 90-day period to renew their authorization. So in the next 90 days or so, they're going to have to renew. Well, if we move forward with this amendment for the oil and gas, what we don't want to have to do is have all those people who just went through the renewal process to turn around and renew again. So we're planning to move forward with this amendment as a straight amendment without renewal. So what that would essentially mean is it would keep the same expiration date. We can't issue a permit for more than 5 years. And so all those folks who just went through renewal would be able to continue operating under the permit. After it's amended, they would not have to submit a renewal NOI. They would just continue operating under their authorization. And then any new entities that come in under the amended general permit would have to submit their NOI and comply with the requirements as they're spelled out in that general permit. So for anybody who has a current hydrostatic test general permit authorization, we wanted to make sure that we were cognizant of the fact that y'all just went through renewal and didn't want y'all to have to jump through that hoop again. So that's one of the things we are planning to do in that amendment. Any questions on our amendment for the hydrostatic test general permit? Okay. And our last topic is the EPA general permits. So EPA currently has 3 general permits that cover oil and gas discharges. So there is one that covers stripper wells and coastal discharges, and that's TXG 330000. That permit, as well as the discharges to the territorial seas, which is TXG 330000. Both of those permits are currently administratively continued, which means that EPA has initiated renewal but has not finished that process. And so what we are planning to do once we get delegation is to adopt those as TPDES permits. So one of the things that we're contemplating now is, so EPA has 2 permits, and from what information we've been able to gather, one of them has like 14 permittees, one has about 15 permittees. So they're very, very few discharges under those permits. And so if we could roll both of those permits into a single permit, it would allow us to authorize all of those through one general permit, which would eliminate the need for us to renew 2 general permits every 5 years. There's a cost to the state associated with renewing general permits. The state of Texas, TCEQ, has to publish notice in the newspapers and in the Texas Register. And so there's a cost associated with renewing general permits. So if we can have a single general permit, that would reduce the cost to TCEQ over time. So that's our plan for EPA's permits, is to adopt them and potentially roll them into a single permit.
In talking with EPA, the one for stripper wells, I think there's just a minimum number of facilities covered. I think it's 15. Charles is nodding. And also the territorial seas, there's a small number. I don't know exactly how much, but it's a small number. But we want to make sure that whatever mechanisms are available today, well, those are expired, but potentially available today could be available when we take over the program. And so that's why we're going to have our staff, Preet, who's right there, start working on those as well. So.
All right, any questions on that topic or any of our topics?
I'm sorry, did you say there were 3 general permits, or you said there were 2?
EPA has two general permits.
And you're talking about making them as one general
As
permit.
one general permit. And they do have a third one. It's GMG 290000. And the reason I had to stop and think about that one is out beyond the territorial seas. And so it's not issued we understand it's not issued under the TPDES program or NPDES program.
I guess my question on combining those two would be, they seem like different types of permits, one for stripper wells and one specifically for coastal waters. Are they similar enough that you can combine them, or you would just have one general permit with kind of 2 parts to it?
It would likely be 2 parts,
Okay.
because each of those general permits is under 2 subparts of 40 CFR Part 435. And so rather than have 2 whole separate permits for each subpart, we would have a single permit, and we would have like section B is going to be the stripper wells, and then section C would be the offshore.
And Cyrus, I don't think that's unprecedented. You know, like in the stormwater program for the MSGP, which is for industrial stormwater, based on your SIC codes, you get these requirements. There's some general requirements that apply to everybody, but then based on the SIC code, you may get additional benchmark parameters. And so that's not unusual to have a Part A, Part B, Part C, D, et cetera, for the general permits.
All right, so I'm going to throw the door wide open. Any questions in general? Things maybe we should know about, things you have questions about that may inform us of, for instance, like the last time, the transition of how permits are going to transition from railroad and EPA to us kind of gave us a, hey, we should probably address that. All right, do we have any questions on the web?
No questions from the webcast attendees.
Okay, we do have a question.
I'm sorry, I went back before the web. When you were talking about the stripper permit, would you also include agricultural use for surface discharge west of the 98th meridian?
So
Would it
right
be
now,
under that same?
So right now, that's not covered under EPA's general permit. So right now, our thought process is to roll both of those existing general permits into a single TPDES general permit. We have not discussed or contemplated the west of the 98th ag and wildlife use at this point.
But you will
No, not
contemplate
at,
that or no?
not at this time.
No.
No.
Other questions? All right, with that, I will turn it over to David for our final announcements.
Okay, so our next meeting is going to be June 15th at 1:30 in the afternoon in this very same room. I know that's the heart of the vacation season, so I'll be canceling all my plans to make sure I'm here. So, and with that, we'll get to, did anyone have any other questions that we could field for you? All right, well, thank you very much for coming today, and we'll see you on June 15th.